Good evening and welcome to the citizens of Southwest Florida. We are broadcasting live from the Lee County Commission chambers. We would like to thank our viewers who are joining us on Lee TV, Collier TV, and Charlotte County CCTV. My name is Anthony Thomas Jr., and I am Chairman of Citizens for a Better Fort Myers Government. We have an excellent panel who will be discussing the state Florida trespassing law. It is our hope that at the end of this town hall meeting, you, the public, will be more informed about this important state law. With that, I turn it over to the moderator.
Good evening, everyone. Let's begin with the introduction of our panel. On my right is Professor Dennis Fahey. Professor Fahey is a third-generation police officer following his father and grandfather in law enforcement. He currently holds a master's degree in criminal justice from Rutgers University and has lectured at numerous colleges and universities in the field of criminal justice. He presently holds the position of Professor of Criminal Justice at Edison State College and teaches criminal law. Beside Professor Fahey is Kathleen Fitzgeorge. She is the Chief Assistant Public Defender for the Twins Judicial Circuit. She received her BA from Cleveland State University and her law degree from the University of Dayton. Upon moving to Fort Myers, she began her employment with the Public Defender's Office in 1991. She is currently a capital litigator in the Homicide Division and actively involved in the defense of those facing the death penalty. She is responsible for numerous high-profile cases and complex litigation throughout Southwest Florida. She is a board member of the Florida Public Defender Association, a member of both the National and Florida Association of Criminal Defense Lawyers. She advises and teaches lawyers throughout the state to aggressively defend against the imposition of the death penalty and on various topics relevant to the practice of criminal law. Kathleen also serves on the Visitors Board at Ave Maria Law School, where she is a mentor to law students. She is currently a candidate for a master's degree in public administration at Florida Gulf Coast University and is actively involved with the Edison Festival of Light. To my immediate right is Mr. Willie Green. Mr. Green is a retired businessman and former president of the NAACP, past president and CEO of the SCLC, and he has lived in Fort Myers since 1953. This was once the largest minority employer in Lee County and is the oldest life member of the NAACP. Governor Charlie Crist honored him as a 40-year foot soldier for civil rights. Mr. Green's philosophy is that you should not ask him to do for you what you are not willing to do yourself. To my left is Derek Isaac. Mr. Isaac was born in Fort Myers. He attended Fort Myers High School on his way to the University of Florida, where he obtained an undergraduate degree and Florida State University for his law degree. Derek has been admitted to the Florida Bar and currently practices civil litigation with a focus on housing at Florida Rural Legal Services here in Fort Myers. And on the far left is Larry Justum, who is currently a prosecutor at the Office of the State Attorney. He is the Lee County Court Division Chief and has been since 2003. Prior to that, Mr. Justum was in private practice and has been the Fort Myers City Attorney from 1989 to 1991. He's a member of the the 20th Circuit Juvenile Justice Council, the Southwest Florida Police Chiefs Association, the Florida Prosecuting Attorneys Association, the Florida Bar. Ladies and gentlemen, I present to you your panel on trespass. I thought we'd begin with some very basic concept questions, and I will direct my first question to Mr. Justum. Mr. Justum, in terms that we can all understand and begin to discuss, what is a trespass?
In non-legalese,
Please.
if a person has authority over a place and they tell you you're not allowed to be there, you're not allowed to be there. And if you remain, you are then trespassing. If they have the authority and control over that piece of property, structure, etc.
Okay, can you give us an example?
If you have someone ringing your doorbell at 10:30 at night trying to sell you something and you tell them to leave and they say no, they are trespassing after you have told them to leave, if they are on your front doorstep and it's your house.
Okay. Can trespass exist, and what you've given there is an example of a private residence, can trespass exist in a private or public context?
Yes.
How so?
Actually, that gets a little bit more complex. The courts make up the rules when you're going into the fine details of where a person can be or where they can't be. And I'm going to defer to some case law that I brought, but I've pared it down into the breakup from what the courts say. There's three different kinds of public property. One is traditional public forum. And there are areas in society that are owned by the government, whatever government, whether it's a city or a municipality or a county, that their intended purpose is for the expression of free speech. And in the case, they use the example of parks and settings of that nature, where they're open to public discussion and public discourse. They are traditional public forums. There are then designated public forums. They belong to the government, but for specific reasons and purposes, they are opened up for discussion. And this would be a perfect example of the County Commission chambers. We were invited here for public discussion. It is a designated public forum. There are also non-public forums where they belong to the government, the people of the United States and the state, but their intention was not to encourage open discussion. They are just property that belongs to the government. The particular court used a lot of different examples. A military base would be an example. It belongs to the government, but there's a high degree of security and need for control. It is not a place where someone is allowed to go to express their opinions. A interstate rest stop was interesting. And most of these are people handing out pamphlets and posters wanting to protest in that context. And there was a case involving an interstate rest stop. That is not a place that is normally open to dissemination of public discourse, conversation. Go to a park, but not a rest stop. A sidewalk in front of a post office was declared not to be a place for public discussion. An airport terminal, a federal building, a county jail, and public housing has been declared not to be an area where it's open for public discourse. So of those three, you have an area where we all know you can go and gather, and people can gather and discuss and protest or speak out, speak their mind. There are some that you can be invited to do that, and there are some areas that the courts recognize, even though the government owns it, you can't do it.
Okay, thank you very much. Ms. Fitzgeorge, if I could turn to you. In your role in the Public Defender's Office, and I understand now that you are dealing with obviously the most grave, serious sorts of crimes, but do you have any idea of how many trespass arrests might be made, specifically in Lee County, but maybe the 20th Circuit if you know, on an annual basis?
I do not know that specifically as to what the actual statistics are. We do represent many people that are charged, arrested for trespass throughout the 20th Circuit. I don't have the specific numbers on that.
Well, if not the specific numbers, then I mean, could you qualify it at all? Would you consider it a prevalent misdemeanor? Is it something you see often kind of come through your office?
We do, yes. Yes, very common in the misdemeanor courts, certainly.
Okay. When you see those cases come in, who is typically assigned to help people who have been accused of that?
Someone would come through first appearance. They would be evaluated to determine if they qualify for the services of the public defender. And at that point, we would be appointed, they would be assigned one of the misdemeanor attorneys,
Okay.
who are members of the Florida Bar, validly certified and work in our office. Whereupon they would then meet with that attorney and discuss possible defenses and how they wish to proceed.
Okay. Okay. Professor Leahy, let me ask you this. Do you see from your position, I guess from a more academic standpoint, Is there a difference between a civil and a criminal trespass? Professor Lee?
Yes, of course there is. When we talk about a civil trespass, we're talking about a non-criminal justice involvement in it. With a civil trespass, we see somebody coming onto your property that would normally not belong there, and you're asking them to leave. One person is being arrested, and another person is going to be litigated through the civil courts itself.
Okay, so would Mr. Justum's example of an unwanted solicitor being an example then of civil trespass?
Under those conditions, I would imagine it would be a criminal trespass under those conditions. One, it's at night, it's at a residence, people are in fear, they've been verbalized to leave, they refuse to leave, and the police are called. Keeping in mind that with trespass, notice has to be given.
Okay.
It either has to be verbal or it has to be in written form.
Okay, let's discuss that. What kind of notice has to be given?
Well, we see trespass take place, let's say, in an agricultural area where hunting is going to take place, and we see posting taking place. Now, the statute reads that under those conditions, posting has to take place every 500 feet along the property line. In a confined area, let us say something open to the quasi-public, a store, where you don't want trespassing taking place, you can, or let's say it's as the gentleman mentioned, an area where the public isn't invited but owned by the public itself, a housing development. That housing development has rules and regulations saying that only those people that live there and or their invited guests should be on the property itself. They can post at every entrance a warning saying that there is no trespassing. You must either be a resident and or an invited guest for that to take place.
Okay. Ms. Fitzgeorge, I'll come back to you. When you say that trespass is a misdemeanor, and obviously we're speaking there of criminal trespass, not merely a civil warning, what kind of punishment would someone be in jeopardy of if they were in fact going to be convicted of criminal trespass?
Well, there's two levels of misdemeanors,
Okay.
a first degree and a second degree. Second degree misdemeanor would be the most basic level, and what Mr. Justin was referring to, if basic trespass on property. That could subject someone to up to 60 days of incarceration or 6 months probation. The second level is the first degree misdemeanor, and that's if someone is trespassing in a structure or a conveyance, a car, something like that, and that could be up to a year incarceration.
So obviously something that could have some dire consequences.
Yes, it could, yes.
Okay. Mr. Isaac, I'll turn to you. In Florida Rural Legal Services, do you ever, or how often do you deal with the topic of civil or criminal trespass?
We've seen it quite often. It's more word of mouth. We deal with a lot of people that have been terminated for other reasons or are facing eviction from public housing. And in that context, they've had relatives and or friends that have been trespassed. We do have a handful of people that have come directly to us for trespassing issues, and we're evaluating those as they come in. But I would say that its frequency it's you know, we talk about it. It's enough to make it a topic at our office, I would say.
Okay. And how would your office typically handle a complaint like that? Someone comes to you and says they've received a trespass notice. What do I do about it?
Well, there's a bit of a gray area there. Our office only handles civil stuff. So we don't have any kind of, our funding doesn't allow us to do any kind of criminal defense or prosecution or anything like that. We can't do any criminal defense. So we evaluate it from a strictly civil standpoint. And with the claims going up, I would say we've looked more and more into constitutional claims and maybe 1983 discrimination claims, things of that nature. But we're still evaluating, you know, the facts as they come in. I would say it's very fact intensive as far as what facts surrounding your trespassing warning. You know, if you're stopped for trespassing and then also found later with something else. I think that their facts, it's tougher to defend something of that nature.
Okay. Ms. Fitzgeorge indicated that criminal trespass carries the potential, obviously not always mandated, but the potential for incarceration. What do you see as the penalties for civil trespass?
We've never had a person come in and say, "Hey, I've got a trespassing warning and I'm getting sued for it." Since I've been there, I've never recall having seen anything like that. I don't, haven't heard any tales of it.
Do they have to pay a fine, or?
As far as I know, civil trespassing covers a fine. It's a fine that is required.
Okay.
But like I said, that's not something that our office generally would handle. It's not something that we see in the context of a client of ours being sued for trespassing. If it comes up in our office, it's more so going to be someone's been arrested for trespassing, or a friend of theirs has been arrested for trespassing, and they're trying to go forward from that. You
mentioned earlier that you might also be dealing with potential eviction issues?
Correct.
Tangential to that, how would that work?
In public housing, oftentimes if there's many different lease provisions, but public housing has become more and more strict about trespass happening on their properties, trespass happening in the residence of their tenants, and in that context, they've crafted different ways to evict people for it. So, say you're a tenant at a housing authority, you have someone who's been noticed for trespassing in your place, and they have to be arrested at your residence. That has caused termination notices to come out. We disagree with those notices, but it has caused those notices to come.
Okay. Mr. Green, in your experience, have you ever seen a situation where someone's being evicted or dealt with it where friends or family members or whomever are in a public housing facility, but as a result, it's had magnified consequences?
It's almost a daily occurrence. My office is handling at present more than a dozen trespasses that were a person were not really trespassing, but trespassing were used to carry out some other type of endeavor, such as in many instances a mother lives in public housing. Father wants to come visit the children. Mother don't want him to come around to visit the children. The courts say he have visitation right. The housing authority acts then as, in many cases, as both overriding the decision of the judge by something trespassing. Then that disturbed me, as a matter of fact, to the extent that the ACLU and myself is working now desperately to change this, because this is not trespassing. This is long-arm practicing of law. They are literally preventing fathers from visiting their children. They are dividing and causing a division in family. So instead of building family, they are destroying the family structure. And this is being used, as much as Mr. Isaac said, in some cases for the case of eviction. Eviction is eviction. Call it like it is. If I have a reason to be evicted, then evict me for what I have the reason for, but not charge somebody with trespassing so as to create a criminal element around the apartment, and then use the clause in the lease to evict the person now, because they literally create the environment of trespass or of criminal activities, and then use that. Just go pay your $400 like everybody else and have the person evicted. But instead of paying $400, they use my tax money and my police power that need to be chasing down murders to go out and write a bunch of trespassing. It's bad for police, it's bad for the community, it is really bad for the relationship between police and the community, because many of these young fellows have information that they would gladly share with the police, but the police has created a bad taste in their mind and mouth with crazy trespassing. Just today, just before I came here, a young man never know that he had been trespassed. Maybe he had been trespassed, but just didn't know it. And he tells me that he just stops to talk to a friend, and he was told, "Show me the trespass warning," that he was told that he had been trespassed not from that housing or public housing project, or as they like to call it, I guess, development, far from development. I'm starting to call them penitentiaries. But they really takes that trespassing and says to him, "We don't want you back here anymore." Now, this didn't necessarily have to be the desire of the person living in the apartment. That apartment, once I lease it from them, that become my resident. And I am certain, having become my resident, I have a right to say who come and go there. But instead, somebody who sits in an ivory tower built by taxpayers' money that decide that they're going to trespass one person because the person visited one development, and that's good in all of them, 13 other ones. There's got to be something wrong with that. Something wrong with it. But really, they turned the Constitution upside down with trespassing here. And we'll certainly be fighting. I believe that trespassing is probably the most misdemeanor committed crime, mainly because people don't know they're being committed east of the railroad track.
Okay.
Now, the sad thing about it, they're not being used any other place. I just listened to Ms. Fitzgeorge. She didn't have any statistics. I'm amazed that she would not have them, because so many of them is just east of the railroad track. As a matter of fact, I asked for a list of the trespassing that were committed west of the railroad track and south of downtown Fort Myers, and I got none.
Who did you ask for that?
Pardon?
Who did you ask?
Oh, I asked the police department.
Police department.
I asked the same people who writes the
citation.
trespass citation.
To see if they keep those
That's
statistics?
right. I got none. As a matter of fact, I asked for a period of the last 90 days, and there were none. There may have been one 20 years ago, for some guy might been an undesirable person with a loud muffle or something on his car, but
yes, sir.
Nothing recent, nothing within the last 90 days. And I have, as I said, more than a dozen that we will be defending laying on my desk now, and it could easily be 2 dozen if they could catch up with me.
Well, since you raised the constitutional issue, let's go back to Professor Fahey. Do you see a problem with a housing authority substituting itself or overriding what Mr. Green describes as a judicial order?
Oh, I certainly do. But we see case law where the Supreme Court has ruled on several different occasions about similar issues. Now, I would think, and I certainly will defer to counsel here, far more knowledgeable than I in the law, but I would think that if there is a court order in place for a father to see a child, and the mother does not want to see the father at her residence, he certainly would have the option, I would think, under those circumstances, to see the children in another location. He shouldn't have to necessarily see the children at that house. He can see them at the park. He can see them at a restaurant. He can see them in any number of places. If the father insisted on going into her private residence and she does not want him there, she certainly should be able to tell him, "I don't want you in my residence." Now, you can certainly see your children, but I don't see it as a constitutional question, a First Amendment question, especially under those conditions. There are options available for that father other than going to that specific residence.
Okay, all right. Mr. Justin, do you see from the state attorney's office, and we've got some statistics in front of us, as Mr. Green has suggested, do you see trespass as a, for lack of a better word, a gateway into more serious crimes?
I don't know that trespass is a gateway into it. It's a standalone offense. Sometimes as people are being arrested for trespass, They may have other crimes that become evident, as if they have a pocket full of narcotics or something of that nature. One of the cases that came out of Tampa, and there is some case law about authority and constitutionality. It's interesting that the Tampa case was about a housing authority, and the court recognized in that particular housing authority, and I can't speak to the Forest Housing Authority or their rules or what they have in place, but in Tampa, the court recognized that the restrictions on the access to the property that were made by the housing authority, that they were content neutral and they were reasonable. And the purpose behind the rules of authorizing the police to be able to tell people to leave that particular housing authority directly related to the crime problems and, as they put in the case, the rampant drug problem. So they had to have a rational and reasonable basis to place the restrictions, but if they had a reasonable, and because they had a reasonable, rational problem that they were addressing by asking people not to be there, the court upheld that ability of the housing authority to say, you can't be here. And it boils down to the example that was given was a mother who didn't want the person at her house. It becomes trespass when that is communicated to that person. Mr. Green is absolutely correct. The courts recognize that we, as a regular practice, understand that if a person rents a property or if they own a property, they have the right to have whomever they want come to that property under the criminal statutes. If they have a valid lease that prohibits them from having a particular party at their house. I had a lease once that said my dog had to weigh less than 50 pounds. And he got a little heavy and they came and knocked on my door. So there was a valid reason and it was a reasonable, we argued a little bit about it, but I went and moved somewhere else. But for a mother that is trying to use that to keep someone from seeing their child, I'm a firm believer in people need to see their children, but that's addressed in our civil courts. My concern is if that woman or police officers authorized by her or authorized by the housing authority tell that person to leave, you need to leave, and he doesn't, then he has had the communication to him that he's no longer welcome. And communication is the key. He has to be told. And in my mind, not speaking to specifics, but you have to be told you're not welcome on that property, not one of the other housing authority properties. There has to be direct communication, and that's key. And then there has to be a refusal to leave. And I'll give you an example. I had an officer call me 2 weeks ago. Said I was driving down the road and I saw a scooter in somebody's driveway. So I stopped, saw a person coming around from the back of the house. And he had leaflets in his hand. And he was advertising for water services. And he says, is that a violation of the peddling law? I said, I don't think so. He said, well, can I arrest him for trespass? Because he was behind somebody's residence. And I said, not unless there's a no trespassing sign. It's not right, but you need to communicate to him if you have the homeowner's permission. And he said, Dad, it's your house. And I went, whoa, excuse me? There was a guy coming out from behind my house. My son, who was an officer, saw him. He stopped. It's like, excuse me, why are you at my dad's house? And I says, no, you can't do anything, but you're more than welcome to communicate to him my desire that he no longer be behind my house. And at the end of their communication, he left. But there was no charge there. There was no criminal charge. Now, was I unhappy that he was behind my house? I was very unhappy. But the law says until it's communicated, nothing can be done. And as soon as it was communicated, he left post haste. So the communication is key. You also have to have the authority. In that case, I authorized the officer to tell him he's not allowed behind my house. In these cases with the housing authority, the courts have regularly held that the housing authorities can authorize the law enforcement officers to act on their stead and tell someone you can't be here. And as long as it is reasonable and content neutral, that they're not singling out individuals because of groups, or they have a reasonable basis for that information, you can ask someone to leave and it will stand up. And what that person needs to do is, if they object to it, they need to leave, and then go to the civil courts and address the issue there.
Ms. Fitzgeorge, I'll come back to you. Would that communication and authority be some of the defenses that might be looked at if this were going to be a criminal trespass?
Absolutely. I mean, if someone leaves, certainly, there's no probable cause, there's no cause to arrest. If there's no notice, if there's nothing posted, it was never told to them that they needed to leave, then certainly those would be defenses. I think Mr. Justin brings up a good point also, that property owners have rights too. They have a right to have someone on their property. They have a right to ask that person to leave, so it doesn't always result in arrest. Those are some pretty valid points, and those are valid defenses to the charge. Certainly the court of law is then the place to dispute that and to work that out.
Mr. Green, have you ever seen cases, or have people come to you with cases where a trespass notice is issued and the person, if they don't immediately depart, is then arrested?
Yes. Yes, and matter of fact, the thing that happens so frequently is that for housing authorities, authority begin and where it ends is always questionable. For instance, the housing authority owns the property where the building is set in the yards and accesses and entries, but they do not necessarily own the road that comes up to it. It's a public road. Me or anybody can drive down the road, but a person that has been trespassed will get stopped in jail if he's caught even on the road. And one subdivision, I won't call the name, that the road leads by public housing and then on to private houses in the rear of the public house. And the only way to get to those private homes is to pass the public. So you don't know where I'm going until I get there. And how can you arrest me, and this is happening quite frequently, before they get there, even though they're en route possibly to the public housing, but nobody knows that. They're on a public street and they're en route and could well be going to the private homes in the rear. And that's the only way to get there, to pass by the public housing that's operated by the housing authority. These people that I have a number of has gotten, of course, in every case, they get before the right judge. In some cases, one of the persons served was kept overnight, and the judge gave him time served, and the others were just dismissed because of that, because they could not prove that he had intent of going to or on public housing property. Yeah, that's always been and will always be a contention between the general public and public housing as to where their jurisdiction begin and where it ends. I think it ends at the sidewalk. There are instances where I have been able to get judges to agree, but there have been some instances where the judge said, well, wherever they say it in. Well, then maybe they'll say it in Washington, D.C. at 1600 Pennsylvania Avenue. That's the largest, most public housing place I know of. Yes, so maybe that's where it ended, all the way from my house to that house. And
well, according to Mr. Justin, it's his backyard.
Well, backyard, but what about front yard?
Yes, sir.
That's what I'm saying. There's so many things wrong with, and it may not be anything too much wrong with the law, but it is certainly much wrong with the way it's being enforced here in the city of Fort Myers.
Okay.
And as I say, I have lived here for some, I guess, 57, 58 years, and this is the worst I've ever seen it. And once it's like a cancer, it just keeps eating it away. And it's doing, I know what, I heard the public defender say that, well, maybe they could go and have the order at the judge. But I said they wouldn't. I wouldn't not want to have to pay child support And of course, I happen to have been a person who paid some child support, and I wanted full access to my children. And that's not full access if they got to take them to a park or someplace to meet me. What if I want to see them at 10 o'clock at night? They got school the next day. You're going to bring them to a park or something? It's a terrible inconvenience. There's no reason, if the mother is not saying anything, there's no reason for public housing authority to set up and play judge and jury and cause these, and most of these mothers, most of them that I have had to do with, if they really went to the housing authority and said to the housing authority, I want my ex or my baby's father trespassed, that would be fine. But they're not waiting for them. In fact, in some instances, the mother comes along to my office with the father, complaining of the fact that the father is being trespassed.
So the police or whomever is authorized by the housing authority to issue the trespass citations aren't waiting for there to be an actual complaint.
That's right.
They're issuing the trespass, and even if they come back at the invitation of the leaseholder.
A grave injustice is being inflicted upon the public, and mainly upon the poor, because if those of us could hire a judge, I never get trespassed. I go in all of the projects. I have relatives and whoever live, and I go and I park, and I have even had Pat Brother Anthony and I to try to get trespassed, and we haven't get yet. People who don't have a job, who cannot come up with the money, and possibly not even get the public defender to defend them, certainly not the way that they would need to be to fight strong and bring up a suit or whatever. They get trespassed. And I think I heard Mr. Justin say a few minutes ago that it is based upon long as they're not discriminating. That's what brings me here. They are discriminating. Because whenever they will start to trespass an insurance man, I surely don't want them out there. When they start to giving insurance men and peddlers and whoever trespass, then I'll say they're not discriminating. But not some poor guy who's unemployed and then he winds up in jail the next day.
Okay, so
I can tell you a few years back, in another life as a defense attorney, I was trying to have an open discussion in the lobby of the Lee County Jail, and I was invited to leave. And they brought out a few people that were going to show me the door too. So I have been there, but I know what you mean. But you've used two different examples, Mr. Green. One is where the tenant, the young lady, wants the man there. The law is very clear; she has the right to allow him there, and that you cannot be arrested. You can always be arrested for anything, but you can't be convicted and charged with trespass if the owner and resident authorizes you to be there.
But what if they've been previously issued a trespass warning?
That's neither here nor there. A trespass warning is only a notice to the person. That's the communication. The second thing is they have to have the authority. No one can tell me who I can invite into my home, whether I rent it. If I violate the lease, then they can go into civil court to try to evict me if they want. But no one can tell me who I can invite into my home, whether I have my home as part of public housing or whether it's a rental through a landlord or through a mortgage company. But if the owner of the home, the person with the authority over the home, the tenant, wants someone in their home, law enforcement can't prohibit that from happening. And reasonableness means that they have the right to come and go. I mean, you have to be able to park in the parking lot to get into the house. So they have the right to come and go, and when we see that on a regular basis, we deal with that in our handling of the cases. We do not prosecute people who have authority to be there because the owner of the home or the possessor of the home has authority that supersedes anything that a police officer says. He only speaks for the owner.
Well, you raise an interesting point. I'm sorry, go ahead.
Give us some clarity on the road leading to, that I talked about, the road leading to public housing.
That's a general, I don't have the answer to that because I was recently told by a judge that a road in a gated community is not a public highway, but the public drives down it on a regular basis. So I was in disagreement with that. I know there are some roads that have stop signs and speed limit signs, and they still belong to the property owner. I can't speak to the specifics of public housing in this community as to whether those roads are part of the community or they are an independent county road. I don't know the answer to that. You can't trespass somebody from a public public road. But I don't know the answer as to it within the communities, whether it's a public housing community or a gated community or a non-gated community. And I had a legal difference of opinion with the court that said that you couldn't enforce highway traffic laws within a community because it was a private road. So there are those distinctions. Public housing would have to answer that. The city, they're not even part of the city. They're a separate entity through public housing, but that would be the answer through them. But I do know that there was a case where there were picketers out front of a sidewalk in front of a post office, and the court said, you can be trespassed from there. You can walk up and down it, but you can't park there and protest. So it depends fact specific. And I don't know. It would be pure speculation as to those particular roads, whether they've been given over to the public or they're still only an easement type situation. I don't know the answer. I can tell you I've never seen a case come past me where someone was arrested for being on the road.
I think simplistically, though, if you went to the city of Fort Myers, their engineering department, tell them specifically what street that is, they would be able to look up and tell you what its jurisdiction actually was. And that would answer many of the questions you may be posing.
I can tell you without a doubt, it does not belong to the housing authority. It was there before they were there.
Well, I mean, if it belongs to the city itself and it is a public street
maybe
or
belongs to the city,
public throughway.
But the platted property beyond where the public housing are shows the street as being part of that property and showing where their lot lines come out and then easement to the center of the street. So technically it belongs to the property owners, conveyed to the city for maintenance purpose. Same as your swells and whatever in front anyhow. And they are overstepping their boundary without a doubt. I'm wondering how would a prosecutor be able to prosecute these cases without knowing whether or not the person were on city property, public property, or housing authority property. There's just so many of them.
Well, as I said, I have not seen a case where a person was on a thoroughfare, whether it's a road or a highway. So that's never come up. I haven't seen that. We have, in these cases, we have the burden to prove where they were at and who had the authority. So the housing authority is involved, if it's a housing authority case, in those prosecutions. There are many times where a defense attorney will come forward and say, I have some information that you don't know, and that is that this person was there to visit person A or person B. And we usually ask for that. Give us something in writing, or give us something, not we're doubting you, but have them write something down that I was there visiting this person. And if that's the case, then they have authority to be there, and we don't proceed on those cases. But those are fact specific. There are some people that, unfortunately, as the court in Tampa said, do go to these places, whether it's the Edison Mall or it's public housing or it's the Hess station, and they do sell drugs and they do bad things. And it's those people, that as law-abiding citizens, we want those people not to be there. I want to be able to pull in anywhere I want and not have people selling drugs next to me. But those are just fact-specific instances that we address when we review the cases as part of our role in the judicial system.
I think our host, Mr. Thomas, had a point.
Yes. I had provided you all, I had made a public records request, and I had got some information from the Lee County Clerk of the Court. I believe our moderator has that information.
Yes, sir.
I want to have the moderator reveal the data that we have, and then after he revealed it, I want to ask some questions of Mr. Larry from the State Attorney's Office. So if you could go over the data. Let's first start with just the general data. I think there's two sets of data.
Yes, sir.
The first data is just general arrests, and then I asked for data after speaking with Mr. Green on it. I asked for data that is looking at race. But if we can first go over the general data, and then I have some questions for Mr. Larry after we go over that.
Well, there appear to be two sets of general data. The first is the number of cases in Odyssey. Let me interrupt you right there just for the public knowledge. And I'll pose this to either Mr. Justin or Ms. Fitzgeorge. What is Odyssey?
It's our Lee County Clerk's Office tracking mechanism for cases.
Okay, just a big computer program?
Yes.
Okay, all right. Cases in Odyssey for trespass of the years 2010 and 2011. It appears these have been broken down by agency, and in 2010, it appears that, 2010 and 2011 combined, Fort Myers Police issued 924 trespass citations. The Lee County Sheriff's Office issued 666. All other agencies issued 217, and those combined issued 1,807 trespass citations. The next chart that Mr. Thomas refers to, again looking at 2010, 2011 combined, in the dispositions of these offenses, in the Fort Myers Police, there were 925, again reflective of the same number, 666. Cape Coral Police had 86, and all other agencies had 134 combined. The final graph that we've been given has these broken down by race. It appears these are both the subject of a no information on null pros or all other disposition. Ms. Fitzgeorge, just for the clarification of the people in our audience and the people watching at home, can you explain to the general public what a no information or a null pros is?
When the state attorney's office declines to prosecute that, they issue that as a certificate. They file that with the court.
Okay. And at that point, the case is dismissed?
Dismissed, yes.
All right. So I'll read chiefly from the all other disposition, since we have the first two sets appear to discuss cases that were dismissed. It appears in 2010, 2011 combined, there were in the Fort Myers Police Department 454 citations, and it doesn't break it down by gender, it just says black. Lee County Sheriff's Office is 66, Cape Coral Police is 6, and all other agencies is 16. Hispanic, Fort Myers Police is 5, Lee County Sheriff's Office is 4, Cape Coral Police is 1, and all other agencies are 11. This again says Indian, that is blank with Fort Myers Police Department, 3 with Lee County Sheriff's Office, blank with Cape Coral Police, and 1 with all other agencies. Under a category that is described as unavailable, there is 1 by Fort Myers Police and 1 by Lee County Sheriff's Office. And finally, the last column, white is 279 by Fort Myers Police, 499 by Lee County Sheriff's Office, 66 by Cape Coral Police, and 75 by all other agencies. So, having heard those numbers, and if you don't have those in front of you, I'll be glad to make those available to you at our break. Having heard those numbers, Professor Fahey, what conclusions can you draw from that?
I think seeing those numbers, you can't draw any conclusions whatsoever. We're looking at statistics. We don't know how they were compiled and what categories they came from. You could have a trespass along with a burglary, let's say. We're not individualizing that trespass. I'm making the assumption, and I believe my assumption is incorrect, that we're looking at individual arrests taking place just for trespass. I would believe that's not the case. I would believe these cases also involve other violations of the law, and they've charged these people, these individuals, with trespass as well. Statistically, if we look just at numbers, we see obviously that Fort Myers has a much larger proportion of trespassing violations than all the other agencies combined. We see that violation of trespass apparently is much, much higher in the black community than it is in the white community.
Professor, I'll stop you there. That's not, maybe you're just referencing Fort Myers, but it seems that 454 arrests in the Fort Myers Police Department of black individuals, but it appears that Lee County Sheriff's Office had 499 of white individuals. So do you really see a disparity there?
Well, I do, because we're talking about a county basis and we're talking about a city basis. We're talking about a spread of population.
Okay.
And we look at the population and we look at the statistics. Obviously, the population is much smaller in Fort Myers, than the city of Fort Myers, than it is in the county of Lee. Therefore, the population being larger, the proportion of arrests is much higher proportionally in Fort Myers than it is in Lee County.
Okay. And would you attribute that higher number to simple population centers?
Certainly. I mean, that has to have something to do with it statistically when we look at it. We look at population. What part of the population have been arrested for trespassing, both in Fort Myers as well as in Lee County? Lee County has a larger population, much larger population than Fort Myers does.
Mr. Isaac, having reviewed these numbers from a civil standpoint, what conclusions do you draw?
I think first that they would be much clearer, as the professor said, if they were broken down into a locational standpoint. If the numbers were to say that so many African Americans were getting arrested in public housing, or so many were just getting arrested on US 41.
By how would you do it, by zip code?
Exactly.
Okay.
I think that would probably be the easiest way to do it, or maybe major address in a local area. I think from that standpoint, you'd have a much clearer picture as to where the arrests were happening, and if there was good cause for the arrests to happen. But just scanning the numbers, casually, I would say that they do cause a little cause for alarm as far as the number of African Americans that have been arrested for trespassing proportionately to everyone else. But I don't think that you can base any kind of a civil claim off of just these numbers.
Okay. Mr. Green, I know you've had a chance to look through these numbers thoroughly. Do you feel this supports your position?
Sure, because Cape Coral has twice the population of the city of Fort Myers, with only about, 5 or 10% of the arrests for trespass. It has a very small minority population now.
So it's
Now, let me tell you, go a little further. This county trespassing, you will find 80 or 90% of them was, of course, in Harlem Heights and, of course, Charleston Park, most of them. And, of course, then Lehigh Acres. You will not find the county, and I'll promise you, having a large amount down, we'll say, south of town, so to speak, from Fort Myers Village down, Fort Myers Beach and Bonita Spring and down that way. What happens in the case of city police, and certainly some county police, because you're talking, the county is as the professor mentioned, is a large, much larger territory. But the smallest amount of arrests, trespasses will be in the majority area, and the largest amount of arrests will be in the minority area. Something wrong with that picture. That's not a level playing field, unless it is by the orders of the authorities. And of course, we talked earlier about the housing authorities. Those housing authorities located in the county areas, out in the non-incorporated area of Lee County, also comes into place, such as there's a large segment of public housing out into the county area, certainly in the North Fort Myers area, and I'm sure you will find some of it taking place there. What I'm saying in a nutshell is that we really need to look at where we are putting the burden. The poor is always the unemployed, the last hired, and the first fired. Why in the world would they have to be the first to go to jail too? There's too many firsts there for the poor and those disenfranchised individuals. because of race. And again, I am certain you will find, and we, as I said, we did much of this research that Mr. Thomas has gathered there for the ACLU people, and we'll be doing more. But I'm certain how it's going to come out. I've been in this business for 50 years, so I can smell it when it's wrong. I can smell it out. It's the kind of thing that you can get away with. You can't get away with putting a man with money and a powerful lawyer in jail for trespass. They spend $10,000 to get out, but you can put one in jail that only have $10. What's he going to do? Call Willie Green? And Willie Green is going to yell and scream, and he still got to do some community hours and what have you.
Well, let me ask you about this, though. According to these same numbers, between, as Ms. Fitzgeorge indicated, the no info, which is a decision not to pursue charges, or the null pros, which is a decision to decline prosecution after initially filing a charging document, it appears that 17% of those cases in 2010, 2011 were decided by the prosecution to no longer seek any kind of penalty. So
that's to their honor.
Well, I'm just going to say that's close to 20%, which would be 1/5 of the numbers we're talking about.
That's to their honor. I'd love to have 100%, but.
Well, 100% is unrealistic, though. I mean, you would agree there are some people that deserve trespass notices.
Right. There are some people that need to be trespassed, but the law need to be different in order to trespass. I really don't believe much in the law, and of course, obviously, they're not going to change it just because I disagree, but that's how laws get changed. Enough people disagree and fight to change them.
Fair enough, sir.
And that's one needs some prepping.
Well, let's, on the topic of poor and disenfranchised, I'll go back to Ms. Fitzgeorge. The public defender's caseload is comprised solely of people who have found, according to the statute, to be indigent, correct?
Correct.
Okay. And do you see a problem with, as the professor indicated, these cases may come along and not so much solely on the trespass charge, but perhaps they're coming in from an ancillary standpoint, which they're connected to other charges, possession of narcotics, as Mr. Justin said, or some other case, and then trespass is an additional charge they face.
Frequently, yeah.
Now, do you see, there was a comment earlier, I believe by Mr. Green, that said they will come in and at first appearance the judge will offer them time served and that they'll do it just to get out of jail.
Sometimes, yes, that's certainly
Do you see that it creates a problem for people in that it gives them at least some criminal record?
It can, yes. Certainly, that doesn't happen when there's a felony charge attached.
Okay.
But frequently people they'll come in, they can't afford the bond. And the judge may say, or the prosecutor may say, well, just credit time served will be sufficient. And sometimes they even walk away thinking, well, it was just dropped. We encourage people not to do that, to have a lawyer, to talk with that lawyer before making any decision whatsoever. Let's look at this, let's flesh this out. No, certainly we represent each individual person. We're not looking at this as overall. We're not going to say, well, Mr. Jones, I'd love to help you out, but I got to think about these other 100 people being charged with this, and I don't think it's in their best interest that you enter a plea or pursue this or plead not guilty. And the other thing, we also represent a lot of people. We're on a circuit-wide basis. A lot of trespass charges come from rural areas, and I think these numbers don't really flesh out a lot of the dynamics that happen in Southwest Florida, be it Lee County or any of the other surrounding counties. There are a lot of trespass charges in the rural areas, quite a few. Another thing that we're not seeing here, for instance, there's 3 Indian reservations within the 20th Judicial Circuit. So when we look at this and see, well, gee, the Indian population is very low, I think if we look at the numbers in total, perhaps it would be fleshed out a little more, but I don't think we have a sufficient amount of data here to analyze it from that perspective. But again, going back to the Public Defender's Office, we represent each individual. If there's a problem with another aspect of it, another aspect of whether it's a visitation problem or something to do with the housing authority, we're focusing on dealing with that person's life and liberty and anything that's going to take away from that. So we would certainly encourage someone to then work this out, flesh it out, let us have a chance to look at defenses, not just to go in and say, I just want to get it over with. That's one of the things we really frown upon. Getting it over with doesn't get it over with frequently. So in that context, I'm not sure that we're seeing the total numbers here to really flesh it out.
Fair enough.
If I may regress for just a moment, and perhaps I could pose a question. As I'm looking at the statistics, I'm only picking out Fort Myers Police Department because it's in front of me and the numbers are easy. We're seeing 20% no cross. And the question I would pose is that a normal number under all circumstances for criminal violations that you would no cross 1 in 5? Or is it just distinct to this violation itself? I don't know who I'd pose the question to, but it just jumped into my head.
Well, I think it's an excellent question, Mr. Justin.
You know, I became a criminal trial attorney because I never understood statistics. And I managed to duck that all through college. I never took the first statistics class. I don't understand them. I don't pretend to. Numbers have to be in context. I would take these numbers, and and I don't mean to be facetious, I'd pull off and use them as lottery numbers because they don't tell me anything. First of all, the null process and no informations are deceptive because in the state attorney's office, one of the things we did when Mr. Russell came into office in 2003, one of his first priorities that he gave to me was to put into place a diversion program that did not exist before that. Trespass is one of those charges that we divert people out of the court system. There are people that are asked to leave somewhere and they get their back up and they decide, I'm not going. Well, I was always taught growing up, you don't argue constitutional law with an officer on the street. I tried it a couple times, didn't work. They don't want to listen. They go to jail. We allow them the opportunity to get out of the system without having a criminal record. We don't file criminal charges. So a lot of those no informations are people that we allow to go through a diversion program. And the diversion program essentially is stay out of trouble for 3 months and we'll drop the case. And they're supervised, the county checks and makes sure that they've stayed out of trouble. But after 3 months, if they've stayed out of trouble, we drop the case. And so that would be a no information notice. Law enforcement has the ability, when they're arresting someone on the street, to not take them to jail. And they give them what's called a notice of appearance, notice to appear. The law says that is a charging document. So in order to put that case through the diversion program, we would file a null pros. So in all of those instances, that person gets out of this situation without a criminal offense. They're told what they did wrong. They have to acknowledge they did something wrong, and they just have to stay out of trouble for 3 months. And it's just an arbitrary number we picked that figured that shows that the person's sincere. So some of that 20% of no infos and null process have to be through our diversion program. And so that doesn't mean that we didn't feel that the facts were sufficient to go forward. I will tell you there are cases that on a regular basis, I won't say a regular basis, but there are cases that do come in where a person did have permission, and it is brought to our attention that this person was authorized to be there by the tenant or by the person in authority. And those would be cases we would drop based upon the facts. But those are all fact specific, and the numbers, they just really don't tell me anything, white or black. I know that we're all from this area. I grew up east of the railroad tracks. I went to high school at Dunbar High School, and first graduating class out of Riverdale. So I know the area. I grew up there. We all know the area. The Hess station here on Cleveland Avenue is renowned for trespassing arrests, and they're all transients. I would just guess probably 90% of the transients in this community are white. And they're laying out on the sidewalk, and they've been told over and over and over again, they're panhandling, trying to get money, and they get arrested on a regular basis. I'm sure there are other stores in the community where that happens, where the store owners call up and say, they're back, please get these people out of here, and the police go out and they arrest them. So the dynamics. My guess is that if you did the statistics, and this is only a guess, a large majority of the trespasses would be male. And if we had a female audience here going, or a male audience going, how come you arrest all the males? But I believe that the majority of the arrests for trespass are males that I see. It's not the females being arrested. I don't know what the dynamic is to that, or why, I don't know if women listen better or they're told better, they're afraid to go in. I don't know, but I know that that's what the dynamic is. So these numbers don't really answer any questions for me. They're just numbers, and they're not in context. It's very hard to draw conclusions.
Mr. Thomas.
Yes, I want to say something about the numbers. I want to first say to the citizens of Collier County and Charlotte County who will be watching us, I apologize for not getting the numbers from Collier County and Charlotte County. I just had more ability to speak with our clerk of the court. Our clerk of the court provided us these numbers. They are accurate. I think that when you, and Larry and I may have a disagreement on this, but I think that you can learn a lot. I mean, these numbers are not in the totality of the numbers, but you can draw certain conclusions. I'll just tell you, I'm not a statistics major, but a pollster will poll 500 people in America or in a state. And based on those 500 people and their characteristics, they can get the president's approval rating, or they can get Congress approval rating or disapproval ratings. So we can learn something from the statistics that are before us. I gave all of this data to you all to simply discuss it. I don't want you to draw any conclusions from it. You can draw your own conclusions. It wasn't a instance of picking on one law enforcement agency or another. But I do think these data is somewhat troubling. It's troubling in the sense that you can have a sheriff department, let's say in Lee County specifically, that is probably 4 times larger than the Cape Coral Police Department or the Fort Myers Police Department. And if you look at the data, you see that the Fort Myers Police Department in particular has a huge amount of arrests, and those arrests tend to be of African Americans. I think that is something that's a point of interest that everyone, and we can have future town hall meetings to discuss that. But when you're looking at the data in its totality, you can say, well, this is something that's very interesting. Now, Larry, you and I talked, and I wanted to go over that. I want you to explain to the public the process. Anthony Thomas is arrested on trespassing.
I always hate to use us as examples.
Okay.
Let's say somebody you know.
Somebody I know.
I don't want to
was
jinx
arrested.
myself.
Okay. Anthony, someone I know was arrested for trespassing.
Willie Green.
Can you walk? Can you walk? And I talk to a lot of the judges. I know that a lot of times the court system is filled with a lot of these type of things, and it distracts from other areas in the courts. Could you just explain to the public the process of A is arrested? Walk us through that process.
If a person's gets arrested by a law enforcement officer, one of 2 things can happen. The officer can release him on the street with what's called a notice to appear. You are to appear, and usually it's 3 weeks down the road. You're to appear in 3 weeks in court for what's called your arraignment. The other alternative is they can take them to jail and book them into jail. I can't tell you exactly. Maybe Kathleen can tell you. I know that trespass is one of the standard bonds. I don't know what the standard bonds are anymore, to be honest, on a trespass. But at the time you're arrested, as soon as you're processed, you can bond out even before having to wait till the morning to see a judge. A person who's arrested is entitled to see a judge within 24 hours in Lee County every morning. Anybody that's arrested, I think their cutoff time is about 6 o'clock in the morning now.
I think it's a little earlier than that usually, yeah.
5:30,
3
6?
a.m.
Oh, is it
Yeah.
3? Okay.
There's also the supervised release.
Right.
There's also release provisions too.
You're reviewed before you see the judge to see if you can get out of jail. There's a program called supervised release. They're in the jail 24/7. They will look at the person. They have criteria to determine whether or not a person can just go ahead and be released without having to see the judge. Person sees the judge, bond is set. They are given an arraignment date, again, 3 weeks down the road. During that 3 weeks, the information of their arrest gets sent to our office. We are charged with the responsibility of reviewing the facts on each and every case to determine whether it's legally sufficient to file a formal charge. You'll hear a lot of misspeak or misnomers, this person was charged with this and that. Until the state attorney's office files the formal charging documents, they're not charged, they're just arrested. We make the determination then whether or not we are going to bring formal charges. Along with that determination then is also whether or not this person should be given an opportunity to go through a diversion program and engage in that program. There's all kinds of variables and criteria that we go through in that to determine if somebody's eligible. At the arraignment, if they make it to arraignment and they haven't been diverted and we've brought charges, then they are given an opportunity to plead guilty or not guilty, and we proceed through the trial process.
How long does it take before the state attorney's office makes a decision on charge? Is that usually 10 days?
It is, we are just now getting cases into our office that are going to be arraigned not this Monday, but the following Monday. And so that's 10 days ahead of time, they start to trickle in, and then the week before the arraignment, we are inundated with the cases. They come from the clerk's office to us for review.
Larry, you said in our conversation, and I just want you to clarify that, if a person is arrested, you said that in your office that you guys have implemented a policy that Steve has implemented, the state attorney, that if a person has been arrested anywhere in Lee County, anywhere in Charlotte County or Collier County who are watching us, if the persons whose house they were over send something to the state attorney's office, then you will use that, your people in your offices in the state attorney's office will use that as a basis to go by whether or not they should file charges. Is that correct?
Right. I know it's semantics, but when you talk about me, talk about policy, that's my boss. I have practices. He does policy, I do practice.
Okay.
My practice in Lee County is, and I'll tell you, it's everywhere. We follow the law. The law is clear that if a homeowner or a home possessor, the person in authority of the residence, invites someone to their home, that's not trespass. The person with the superior right and authority over the property. And it's not the landlord, whomever that landlord is, whether it's your uncle or it's your relative or it's somebody that you rented the place from, and or it's the housing authority. And if someone of a lesser authority than the property owner says you can't be there, but the property, and I say owner in the sense that if I'm there, it's my house, I'm cooking dinner at the stove, that's my house. That person authorizes somebody to come over, that's not the crime of trespass. And we don't prosecute those cases. Now, we get that information sometimes when the public defender gets involved or a private attorney, as Mr. Brandy knows, if he were to call me up and say, Larry, I've got an affidavit from the person. Now, I will tell you that sometimes I am suspect of some of the people that claim that the person was coming over. And because we have seen a couple times where 2 or 3 people swear that he was at my house. No, I swear he was at my house. No, I swear he was at my house. But it doesn't matter. As long as they say that, I'm going to honor that. I'm not going to sit there and go, no, you're just covering for him because he's in trouble, or he's a nice guy or woman. And we don't micro manage that. And in fact, one of the cases, it was pretty amusing because, well, I say amusing, probably not for the person in the case law, but the case involved a young man who was on housing authority property and been told to not be there by the police. He was arrested, and they confronted him and asked him where he was going, and he said, my mom has a very good friend here. Well, were you going to see that person? No, but she has a friend here. Well, that friend came in and swore that he lived with her, but he didn't remember that he lived with her. He just knew she was there. He had a name that he threw out. And then the brother came in and swore he was with him. Then another friend came in and swore, no, he was with me. And the court basically says, look, we're not going to, they said that's good enough. And it's good enough for our office. It's good enough for me. If someone says that they've invited somebody to their home, that's not a crime of trespass. It's just not going to be. And we don't prosecute. We prosecute based upon the facts of each individual case. And there are people that have been asked not to be there, and they have no business being there, and they have nobody that will come in and say, I invited them there. They were just hanging out. But they've been told not to hang out. And that is the crime of trespass, because somebody with the authority has told them not to be on that property. They had the authority. That wasn't superseded by somebody who had a greater authority. That's trespass. But if somebody with a greater authority, I want somebody in my house, you can't tell me, no matter where I live, you can't tell me that I can't have them in my house. And I'm not prosecuting somebody for a crime that they didn't commit. That's not a crime. There's no question of whether I prosecute it or not. It's not a crime. So, I mean, that answers your question, but that's not practice or policy. That's the policy of our office. We don't prosecute people that we know didn't commit a crime and that fall within that law.
Okay, Larry, and this is also to the public defender. Either one of you can answer it. Can you tell the public what is the difference between having a trespassing notice posted and having a person actually be physically there to tell the law enforcement officer, this is the person, I want this person arrested for trespassing or issued a citation?
I can explain that.
Go ahead, I'm not sure
Okay.
I understand what you mean by
there
that.
there is a concept called the trespass notice, and I know what you're talking about. It's actually literally a piece of paper that people get that they've been given notice. That is a procedural matter. That has no bearing in the law. What it means is that, let's say, for example, I have my house, or someone's renting an apartment. They don't want somebody over there. They've caused a disturbance. They don't want them in their apartment. They call the police and they say, will you tell this person not to be on my property? That's the communication. Remember where I said you have to have communication. Now, let's say 3 days later, that person comes back, and the homeowner calls the police and says, I told this person not to be here. So the officer's standing there and the person's going, oh, they didn't tell me that. I never heard that. Didn't tell me. Well, the officer that first responded, he isn't there. He's at home. He's off duty that day or at that time. So the officer who is standing there says, I don't know that happened. Well, because of this little piece of paper, a copy of which goes in their computer base and in the police department, sheriff's department, they can pull that out and say, oh, wait a minute. I see that Officer Jones did tell this person 3 days ago not to be here. And what that is that's just the reality of what we call the fellow officer rule. If one officer tells another officer something, they can rely on it. So what it does is it enables the police officers to know that the homeowner with the superior authority has previously communicated the information, so that the person can't say, oh, they didn't tell me that, I didn't know. It's just the proof that the person was told, and we have to show prior communication. It is the functional equivalent of the big sign that says no trespassing. So that's just, the notice is just the means to confirm that the communication has been given.
How long is a trespassing valid for?
Trespass, the notice, the communication.
If you've been trespassed from a location.
The communication is valid as long as the person with the superior authority on the property doesn't want you there. As long as that homeowner says, I don't want this person on my property, that's fine. If they rescind that, I've had people call me up at times and say, how do I go back in the store? I want to go in and apologize. And if somebody gets arrested for theft, they also get a trespass notice. You're not allowed to come back in my store if you're stealing from me. And then 10 years later, they've cleaned up their act, and they will call and say, what do I need to do? You need to have somebody go to the store and get them to say it's okay for you to be there. So there is no time limit. As long as the person asks that you not be there, or communicates to you, you're no longer welcome on my property, it's good to go.
Mr. Thomas, it is approximately 7:30, and at that time, I thought you might want to open the forum up to questions from the public.
Sure.
There was a young lady in the front row that had some questions.
If you're a member of the public and you'd like to ask a question, we ask that you come up to the podium, and you can be specific on who you want to address your question to, or you can address it to the panel. Panel, please identify yourself.
My name is Shirley Bird, and anybody in the panel, because I want to can answer the question. I want to address things that are happening in the housing authority area that I live in. I heard you say, what's your name, sir?
Larry.
Larry. You say that as long as I'm the resident of the apartment, then I have the authority to say who I want to live or visit me and who I don't want to visit me. Now I want to know, with me having that authority to say you can come and not come, but I rent from housing authority, do they override me in this situation, first of all?
Okay.
If I say you can come, housing say you can't come, who gets the rule here?
All right, let me do this. I think Mr. Isaac wanted to answer it, and I'll let Mr. Justin follow up.
I would say civilly, being a housing authority recipient of that benefit, if they want to take any kind of right away from you, they have to go through what's called a due process. So if they want to take away the right of association with someone from you, I would say that the proper way for them to do that is to have a hearing, state to you that they would notice you for a hearing, let you know that we want to trespass someone off your property for this reason, and give you an opportunity to come state that you want them there and why. That's the way I think that our office thinks that it should happen. It doesn't always happen like that. I know the housing authority sometimes will trespass before a resident asks for it.
Well, I have respect for you guys, you know. You all don't live in our neighborhood. You go home at night and we have to live with these problems. Now, I'm giving you real live scenarios here. If we just out in the yard playing a card game, you got the police just ride up, he decide he wants everybody's ID in this crowd, and because I got a felon on my record or he got one on his record, now you get to be trespassed. But you already see me and him, we out in the open, we are not committing a crime. But because I got a prior on my record, you just decide now I can't come to this residence. But the young lady says, well, I want them to stay. These are my guests. They're not doing anything wrong. We in the open, we up under a tree playing cards. You see what we doing, you ride by, there's no crime going on, but because you say I got a prior, I gotta go because you say I got a prior. And this is what's happening in our neighborhood. I'm a grandmother, my grandkids live behind me. So I ask housing authority, you telling me my grandkids can't come into the neighborhood now? No, they cannot. Unless they call you on the phone, say, Grandma, can we come over? Grandmama has to meet them on the corner somewhere and then walk them to her residence. Then when they get ready to leave my residence, I have to walk them out of the neighborhood, because if they catch them there, they're going to get arrested or get a trespassing. Now, I hear all the legalities that you all are saying, but that's not what's going on in reality across those tracks over there.
So you're saying their position is they have to be escorted wherever they're at, that you have to be...
They can't even play on the basketball court unless grandmama stand there all day long and watch them on the park, on the basketball court. They can't walk through Palmetto Court. You got do the sidewalks own to them? My God, do they own the sidewalks? Because this is getting a little ridiculous. They get arrested if they walk on the sidewalk. They can't walk in the middle of the road. They getting arrested. This is if the only time they could stay anywhere in the Palmetto Court. I stay in the Palmetto Court, so I'm speaking for my resident. They have to go across the street into the home sidewalk. They can walk anywhere in the vicinities around the homes, but any of the sidewalks that are adjacent to the property of Palmetto Court, nobody can walk there once they've been trespassed. And I want to know, even the sidewalks belong to them? The point is, the police, the housing authorities, maybe they do have these legalities, but I just think they overstepping. It's just something just not quite right here. I may not know all the legalities of things, but there's just something not quite right here. Why don't you just come out and tell us you don't want us to have no company at all and be done with it, and then let's deal with it from that point of view, because this is just getting a little ridiculous. We can't have gatherings. We can't have family gathering. We can't have Thanksgiving. It's something, you know, and I understand. Look, I give thumbs up. Crime rate has gone down some. I'm not going to make housing look real bad. I stand up for them when it's time to stand up for them. But this stuff they doing now, it just needs to stop. You know, it's like backing a cat up in a corner. After a while, he's going to come out fighting. Somebody's going to get hurt because this is going too far. And so they overstepping their boundaries, and I just want to know, when does it stop? What do we have to do?
Let me ask you about that, Professor.
Yes.
What she's describing, I believe, are not in your individual residence or the place where you have a lease. What she's describing, I think, are trespass notices that have been previously issued, but people are no longer allowed in what may be the common area, basketball courts, out in the yard. Does her authority extend to the common area if she is a lessee?
I don't believe it does. I believe it only extends up to her residence itself.
But even at my residence, no. I'm saying to you, sir, I can't even have company at my home. Point blank, period. If I'm sitting under my tree, we barbecuing, we having card games, whatever's going on, there's no criminal activity going on. We are all laughing, having fun, and whoop, come the police, okay? They whoop in. We want all of y'all ID.
But what I'm asking you is that tree, is that in a yard that is shared by people?
It's common area.
Right.
It's in the yard that I live in. I have a tree in my yard. It don't have to be a tree. We just in our yard, regardless of what.
That yard is common area as far as
So they have to be inside the apartment, you're saying?
You have to be inside the apartment. That area there is common area, and the housing authority can trespass anybody coming in there as long as they're not a resident itself. The other question is, how about we solve this problem in some fashion? How about if we go to the housing? Has anybody gone to the housing authority?
Yes, we've had the Fort Myers Police Department there as well. We've had them all there. I've spoken to each one of them. I told them how we feel as residents about what they're doing to us. Of course, it's just being ignored. But yes, they did come.
You as residents have certain rights, and one of your rights is to go to the housing authority and complain. Your taxes pay for that. Our taxes pay for that. Everybody's taxes pay for that. You have a right to argue with them. You have a right to petition them. And those are some of the things you should do. But to answer your specific question, that tree, common area.
We have a right to argue our point, and then I'm going to tell you what happens to us after we argue our point. Because you get up and say what you got to say, then they look for all kind of other little loopholes.
You get rid of it.
To target you now. I know what I'm talking about because I got my rent hiked to $700 and some. Had it not for legal aid coming to my rescue to deal with this matter, I would be out the door because I told housing authority how I feel. These are the things. This is why you got this crowd sitting right here. You want to see these fruit right here? They won't come because you all won't protect us, the police won't protect us, and then housing authorities get the pen of authority that they can say, we want you gone. We figure out ways. We'll use this young man. If he got a felon, he over there to my house. I want to get rid of you anyway, Shirley Bird. So since you got him here now, cause he's here, I'm going to put you out for having him here. I may not even know the young man had a felony on him. We dealing with a young lady right now, as a matter of fact. She's a white lady. She live in the neighborhood. Now, mind you, I don't know whether she sell drugs. It's kind of been out there, but I don't know that for a fact. But the point is, she had a young man that walked out of her door. He had an open container just the other day. He say he got it off the sidewalk. Well, of course, the police said, let me feel it. Of course, it felt cold. Okay, fine. He know he lied. He say, well, do you have any drugs on him? Nah, him not knowing, he didn't even have to answer that question. He said, well, yes, I have a little reef on me. Mind you, he's outside of my house now. I'm her. He's outside of my house. This conversation now going on between them two. Because he said he had a little reef on him. I'm being evicted. I don't know what's in his pockets because he come to my home. He's in my home. Now once he leave and something on him, because something is on him, now you get the right to evict me out of my home because you caught reefer on him. What this stuff that they're doing is, I don't know what to say, you know. This is just something wrong here. And I think you guys know what we're saying. Why you're not wanting to help the situation, at least that's how I feel you're doing. But it is something going on here, and you guys know what it is, and because we don't know all the legalities of things, then these people get to do and railroad us in the kind of way they want to.
I don't think it's a question that we don't want to help you. I don't think that was the purpose of this symposium that we're having here today. The purpose of this, as far as I was concerned, was education. And that's what I would like to do, is try and educate people as to what they can do and what they can't do, and I'm sure the rest of the panel would agree to that point. Those individual problems that you have need to be addressed, should be addressed, and they should be addressed immediately. Now the question is, who do we address them to? Can I do anything about it? I'll tell you right now, no I can't. I have absolutely no authority at all.
Well, who has the authority? Can somebody
Housing
tell me what
authority.
we can do, sir?
The governor has authority.
I know that some of the cases that you're speaking of, we've had similar facts come through our office, and we've defended in either hearings or in court hearings and housing authority hearings. So I would recommend that if you have issues like that you definitely call Florida Rural Legal Services, and we would, evaluate your facts and do what we could to make sure that your rights weren't being trampled on. But you have to put yourself in a good position to begin with. Okay, you have to know what the laws are. You have to know what the rules are, just so you're not inadvertently breaking them. Okay, so I think it's real important that people do take the time to read their lease. They take the time to read the housing authority, their rules. They have a whole plan, an administrative plan that's written out. I think it's very important that people that live in housing authority property know those rules. So when something does happen, they're not surprised by it, and that they know how to avoid certain circumstances that could be avoided. When you're the situation that you spoke of about the trespass, I think that is something that there probably could be some good defenses to. So.
But I think you're doing absolutely the right thing. You're at that podium and you're making the points, and you need to continue to do that.
I just want to know one thing, and I'm going to sit down. My rights. My rights versus housing authorities' right. All I want to know is, if I say you can come to my home and housing say you can't come to my home, I want to know who has the right here now, who has the legal authority in this situation now.
Housing authority.
Housing authority?
Well, no, I think Larry answered that question already.
Two different answers to that question, ma'am. The first question is, criminally, the person can't be arrested. That person can't be, he can be arrested. Anybody can be arrested. They can't be convicted of the crime of trespass if the person whose house it is says they can be there. Now, if that violates your lease, I don't know. I would have no control over that, none, zero. I had a friend call me up and ask me about eviction. I said, I don't know the answer. I don't know how you do it. And I don't have time to look it up right now. I've never done it. And what you're doing is you're bringing these issues that are valid issues, and we all appreciate that, but it isn't what we do. And the way I commonly explain it to people is, you're asking a foot doctor about something about the eyes. I know where they're at, but I don't know anything about them. So we can't answer, with the exception of Florida Rural Legal Services, and I'm sure they can't do individuals here today, but we don't have the answers to the civil issue. Does that violate my lease, and is that a valid lease agreement? But as far as the criminal part of a trespass, I would never knowingly prosecute someone who is asked to be there by a person with the authority to ask them to be there. The state attorney's office is not going to do that.
Right.
That doesn't say that it might not violate your lease, and you might be in front of Florida Rural Legal Services asking them to see if there's some loophole. So first thing you need to do tonight is go home, make sure you have a copy of that lease, and then have somebody who understands lease agreements and all the fancy words they put in them explain it to you.
Wow.
And I'm not the person to do that because I have a hard time reading them.
Okay, let me just say this to our audience. Our panel here are legal experts from the state attorney, the public defender's office, and a college professor, and someone from Florida Rural Legal Services. They don't have the authority to address the issues you may have, in the sense that they have no control over any housing authority, whether it's in Lee County, Collier County, or Charlotte County. What they are here to do tonight is to educate the general public on Florida trespassing law, so that you may know your rights. Now, one of the things she asked, I think, is a legitimate question that I would put to Florida Rural Legal Service representatives. Does a resident I think we've answered this, but I just want it to be clear. A resident has a right, from what Mr. Larry is saying, to have people come and visit their home. Now, the question to Florida Rural Legal Service representative, the question she brought up about a person who has a criminal record, and you are a housing expert, whether you live in Collier County, Lee County, or Charlotte County, is it within federal law or HUD rules or regulation that a person who has been convicted of a felony cannot visit someone who lives in public housing?
There's a caveat. It allows for the housing authorities in the different areas in their plan to set up. Each housing authority has its own, essential set of policies and rules that they follow, and the CFR, which is the Code of Federal Regulations, allows a wide range of what they can do to enforce general rules. What the rules in the CFR says is that they may not allow someone with a felony record, or they may trespass, and it's up to that individual housing authority to decide if that's the policy that they want to affect. Okay. But they can, in their policy, they can limit the access. They can trespass to a certain extent, violent felonies and things of that nature. I don't believe that, if you have a simple misdemeanor, that they can, write you a trespass unless, it happened on that property, or, it had some kind of nexus to housing authority or one of its residents.
Okay, I thank you for that.
All right, Mr. Thomas, it was the lady in the red shirt.
Okay, please identify yourself, please.
Kimberly Murphy. Yes, I'm here because my son, they was getting out so many trespasses out there. The officers, like 5 of them was out there. They seen him sitting on the porch eating. As soon as he got to go to the next residence from where we stayed at, he didn't go around the road because, the little path right there. So he walking through the path, and the officer stopped him and gave him a trespass. My landlord asked me why didn't I come to her and take care of it. I said, well, y'all giving him out so much. Why is they giving him out? If he said that he's a resident, he's on my lease, he's a resident, he's been there since 20 years, he's been staying on the lease, and the officer said because he looked like a suspect. So when I seen the officer and asked him, I said, what do you mean by that? He said he just looked like he was suspicious. I said, well, what do you mean by that? I said, he's on my lease. I said, y'all have a lease showing everybody that stays in the resident with their pictures and everything, so what kind of suspect did he look like? They're giving so many of them out to it doesn't make sense. My nephew, football player in school, he came to my house. I said, why you give him a trespass? Because if he want to walk, he have to walk around the road. He cannot cut through from the basketball court, because my apartment is in front of the basketball court. He can't walk through the basketball court. He got to come around. So he said, okay. I said, I got you on that one. I walked my nephew back to my other sister's house. He seen us walking. He said, why isn't he to your house? I said, because I'm walking him back to my other sister's house. He said, well, okay, I got you. He gave him a trespass. I said, but he's walking with the residents. He said, it doesn't matter. He getting a trespass, and I want him up out of here. And we took him up out of there. So the next thing, I wasn't home one day. We was getting ready to go out of town for Christmas. And I was at my cousin's house getting the tote bag to take out of town. The officers around in my house, so I'm like, what's going on? He said, I need to search your house. I said, why is that? He said, because a little boy that had a trespass. So I said, well, no, couldn't no little boy went in there. So I opened up my doors. I said, go ahead on and take a look. He said, you know what? He probably ran out the back door. I said, no, officer, go check that back door because it's locked. And then he said, no, I don't need to go check nothing because he probably ran out the back door. I said, no, the door is locked. He said, I tell you what, I'll see you tomorrow morning, ready to get your stuff and get out. And I'm going through it right now with a 30-day notice of getting kicked out from some little boy walked on my porch and walked off.
Okay.
And I asked the rent lady about it. And I told her I was going to her boss. She told me it doesn't matter where you go, because my boss ain't gonna do nothing but rip it up and throw it away. It doesn't matter what y'all come and tell her about me, because she ain't gonna never find me to listen to nothing y'all gotta say. So now I'm on the verge of going to the news press, because somebody have to listen to, you know, what us residents are saying, because we don't have anybody to speak for us. That's why we trying to get somebody that's, you know the words about the laws or whatever to speak for us, you know, because I don't know anything.
Yes, ma'am.
I'm just going about what the officer's telling me what I supposed to do. I went to work, when the officer say do this, I did it. Oh, you steal it? I said, well, which way y'all want us to go?
Let me ask you this, and I can understand the story you're given. Was there a question you had for somebody in the panel?
Huh?
Did you have a question?
Yes, the question is, what is really going on with this outcome? I really don't understand it.
Mr. Green?
As best I wished I had one that would make her feel good. As best I understand it, this housing authority, I've actually did what we are recommending here. I've actually met with the authorities. I've met with both the board. In fact, I will be meeting with them again tomorrow concerning the housing in Lee County. The same peoples now is over the county housing, public housing, that's over the city. And I will be meeting with them tomorrow. That housing authority, and I have to say this, and I'm going to say it to somebody, listen, it's not public houses anymore, it's a public penitentiary. I mean, peoples in the penitentiary, people that at the institutions have more rights than the people in public housing. And it was never meant to be that way. I know, as I've heard Mr. Justin, because that's what prosecutors are supposed to do. They're trained to prosecute people when a police said they did wrong. Well, let me tell you, the police was the one that need to be prosecuted, the ones that write those trespasses in public housing. And they are treating the peoples wrong. They are taking advantage of the poor. They're taking advantage of the disenfranchised, and that bothers me greatly. The same thing, and of course I don't have the criminal record, but there's no way for him to know. He don't. I could sit there to that card game and I will not get treated. They treat the people that are defenseless, that do not have the ability to push back, wrong. And I've said that, and I'm going to keep on saying the housing authority themselves, those people, many of them came themselves from public housing. And had they been treated that way, they wouldn't be in executive positions today. Mm-hmm. These county people, the people that operate the county people, are actually treated different from the city because, of course, you got different codes and what have you in the county than what we have in the city. But they go far and beyond what's reasonable in every case. I mean, how in the world would you know? I mean, a policeman got to be awful smart to know who is a criminal, who isn't a criminal without checking. He drives up, and I've seen it in many cases where the people that's coming through from one public housing, it's a pass already made through there, and they just walking through there. There's no intent, or he certainly would not know to do anything wrong. And the next thing, you got 10 or 12 of those young fellows out there, and they trespass. And now the sad thing about it, they cannot catch one once he kills somebody. He can go ahead on and kill somebody, and he can go any way he want to go. Mm-hmm. While he got busy out there trespassing somebody, and the boy that got killed a few days ago, nobody's been caught.
How long do a trespass last for a lifetime?
But well, let me tell you what's being done. This is what we even have applications for you to join. ACLU and SCLC. We are going to sue to change the law. Look, first of all, we're going to sue them. They're turning the Constitution upside down when they prevent me from walking down a public street, and they can't tell me that crap about they own it. If they own it, then that's why do I need a license plate to drive on? If it's a private street, they give me a ticket if I drive my car down and don't have a license plate, and then they turn around and say they own it when it comes time to give you a trespass. Something wrong with that picture. It's terribly wrong. As I said, I've lived here for 57 to 58 years, the worst I've seen. And it's getting worse. It's not getting better, it's getting worse. I can hardly go to my office or leave my office without somebody standing there saying, I just got trespassed. I can't go visit my mother, or I can't go visit my sister. I just wish if I had enough money, I'd buy the place and close it up and let the people stay there and run off the people that's running it.
I think Mr. Justin answered your question, that the trespass warning can exist as long as the person with the superior right to the property wants that trespass there.
Okay.
So that can be the leaseholder if they're, if that's a part of the power in the lease. The state office of the state attorney is obviously charged, as you've mentioned, I think Mr. Green mentioned also, that they are there to pursue justice according to the laws and statutes of the state of Florida. Ms. Fitzgeorge in the office of the public defender is there to make sure they do their job according to the Constitution. So you've got both sides of that scale, and thankfully you've got Florida Rural Legal Services who are helping you on the civil context. So there are avenues through one of those organizations to get some help. There are. Any of those organizations exist to let your voice be heard. Okay? Thank you, ma'am. I think we had another one, the young lady in the purple shirt.
Please identify yourself.
Krista Roberts. I just want to say,
What's your name?
Krista Roberts.
Bring the microphone.
You can move that mic.
I just want to say, where can we stand at with a trespassing? What can we stand? Because I have a trespassing, and my son play basketball. I used to take him to the road and call my family to come get him. Sometime the phone be dead. They say you can walk the road, how I can. Then, like he said, it is help out there, but what can you get help? Like, okay, the police who gave me the trespassing, he willing to lift my trespassing. The lady said, if you be convicted of a felony, she cannot lift it. What law that is? What rule that is? He is willing to lift my trespassing.
I think that's what Mr. Isaac addressed, that you got to look at your lease terms, and if the person is willing to lift that trespass notice, again, according to Mr. Justin, they can make contact and that trespass can be lifted. But you got to look at your lease provisions and see what those terms are.
I don't stay out there. My sister stay out there. They stay out there. They're immediate family. My baby go to school out there. The rent lady said if I'm convicted felony, what my felony got to do with me come visit my family, come get my son off the bus? What my family got to do? So that's a new rule just popped up. What my felony got to do with them? The officer willing to lift my trespassing. Who can I go to now? They say go to the Fort Myers Police Department.
Right.
Went to them. This is the House Authority. House Authority, now you got to go to Fort Myers Police Department. Went back to them. You got to go. I'm going back and forth trying to handle their trespassing to see my immediate family. And she said, oh, if you have a convicted felony, I have a felony 5 years ago. So now, since I got a felony probably 5 years, I can't see my peoples. I can't take my baby off the bus.
What do you think about that, Mr. Isaac?
I think that it's going to come down to what the what I'm assuming you're talking about Fort Myers Housing Authority, what their administrative plan says as far as, I can't remember the exact time frame for the felony look back period that they have. The felony look back period was originally just supposed to be for new applicants. It's not necessarily supposed to be, my understanding of it isn't supposed to be targeted towards guests, but it's kind of evolved into that. I would say that if you've been given a trespass and you're really unsure about why you got it and if I can get rid of it, that you would want to call our office and let us go through the facts with you as to what, how your facts fit the situation of the law. It's kind of hard to say, just hearing general facts without, being able to review the law, how your facts apply to the law. But I would say that, and the young lady that spoke before you, I would say you don't want to let these kind of instances stack up. You don't want to have 2, 3, 4 of these trespassing instances before you go speak with someone about it. You want to document these things as they happen when you feel like you're being wrong. That's the best way to preserve your rights, is to make a documentation of what's happening. So, like I said, I would recommend that you contact our office and try and get a rundown of how your facts fit the law.
And another question, you can't walk in the parking lot? Like, it was one incident I had was late for a doctor's appointment. I didn't want to walk through the road up past my apartment, so I called the Fort Myers Police Department and asked them that I got an appointment and I'm gonna miss the bus. if I don't walk the road. They told me walk around. Walk around? Walk around? I had to walk all the way around and then miss the bus. That's a long way. Why we just can't walk the sidewalk? Not even walking the sidewalk. We can't walk the roads. If you go through the road, you going basically to the store.
Talking about Palmetto Court, right?
Palmetto Court. If you walk the road, you going on MLK. Why walking the road gonna hurt? If you just walking past not stopping, not doing nothing, but just walking the road, going where you got to go.
I think that the state's attorney's office they've already discussed what locations you can be in and be valid to get a trespass. I think this situation that you're describing is something that you might be arrested for trespass, which probably is not a good arrest. But it doesn't sound like it would be something that would be convictable if I'm understanding what.
Again, it depends the location, the ownership. You're talking about, for example, the fellow that wanted to go back and look at my water to try and sell me a different water. He might have thought he was there for a legitimate reason. I didn't want him on my property. I had a superior interest in that property than he did. He might argue with me that he was just back there for a reason. The bottom line is, unfortunately, that there are, in every situation, somebody has greater authority than the other. And I can't speak to specifics. If, in fact, the housing authority has a greater authority over that property than you do, then they win. Unfortunately, you have to try to talk them into changing their mind. As I was talking to Mr. Thomas on the phone, that if I am trespassed from the Edison Mall and I decide I want to go to Sears to buy shoes, I can't shop there. Even though all I want to do is go and give them my money. If I've been trespassed, I can't do it. Now, I might be able to call Sears company up and say, we talk about this, and maybe Mr. Green can set up a protocol, or Mr. Thomas an avenue to talk to the housing authority people. I don't know, but I know nobody on this board can speak for the housing authority or the police department because we are not part of them. All I can explain to you, and right or wrong, is whoever has a greater interest in the property gets to make the decision. And if they have a greater right to that property than you do, and they say you can't be there, you're going to lose. Just the same as if one of those officers knocked on your door and his car had a flat and he wanted to borrow your phone, you might tell him no, because you have the authority not to let him do that. It's just whoever has the greater authority, right or wrong, and maybe you need, as was said, maybe you need to talk to him and see if you can work something out. But specifically as to can you cut through here or there, I couldn't answer that question without knowing who has the greater authority over that property.
Thank you.
Thank you, ma'am.
I have a question for the panel. Let's say Donald Trump says that he wants to give Larry a trespassing, but he says, I own 50 properties in the state of Florida, and I want him trespassed from all of my properties. Could he, when the police officer come and write out the trespassing to serve you, can they put your trespass from all of Donald Trump's properties?
Sure.
Or is the trespassing notice that they're giving you, it has a place on there where you say location. Can it be where they have to list the locations that you're trespassed from?
The trespass notice is just a record of the conversation and the notice. If a person comes to me and says, I own, each one of my motels you're no longer welcome at, then I'm no longer welcome. And I'm not allowed to go there. And if he has superior authority to that property, I'm going to have to go somewhere else. So yes, you can be told that I don't want you on any of my property. Now, whether that translates to housing authority, I don't know. Don't know the answer to that. I don't know what their general authority is. I can tell you, not being specific, but if someone came to me and said, I didn't know that when they told me not to be on the housing authority property, I thought they were talking about Palmetto Park. I didn't know that they were talking about Sable Palm. I didn't realize that, and I would have never done that. And did you have a legitimate reason for being at Sable Palm? Yeah, I didn't go there just to hang out, but I was there to do whatever. personally and professionally, no, we wouldn't prosecute that because the communication wasn't clear. And you have to have communication. If the communication is clear, unequivocal, you do not have any right to go on any housing authority property, and we have superior authority on that property, you can't be there, no, you can't be there.
Okay.
Does anybody else have a question that is non-related to the housing authority? I don't want the housing authority to think we're picking on them. This is a general panel on general trespassing.
My name is Bennett Williams. I want to thank you, Anthony, for inviting me out here. I want to ask you a question. Did you extend this invitation to someone from the housing authority?
No, I didn't think that we would be dealing with a lot of housing authority issues, but when the word got out, I guess a lot of residents from housing came.
Okay. Was an invitation extended to someone from the police department?
Yes, we extended an invitation to all law enforcement.
Law enforcement, okay. Mr. Latham, Justin, I'm sorry, Mr. Justin, thank you for the information you shared. The young lady after Ms. Bird asked you a question. I think she wanted to know, was there a statute of limitations for a trespassing citation? In other words, once you get it, is there a time frame that trespassing citation has an effect, like a ticket, driving citation?
No, because the citation that everyone talks about, that the police give out, that's just a record of the communication. That is not specifically the communication. It has no legal weight. It has no genesis under the law. It is just a form that has been created so that the officers have a record of who's been told what. So it has no legal bearing whatsoever. It is just the communication. As long as the communication is in effect that you are not welcome on this property. For example, if Mr. Green were to go and sit down with that young lady and sit down with the housing authority and they all sat around a table and housing authority said, you know, I'll tell you what, you're okay on our property, then hopefully someone would have them put it in writing in case that person won the lottery and wasn't there the next day. But all right, put it in writing. They're now welcome on public housing property. And then take that down to the police and give them a copy and make sure everybody has a copy. And it would be fine. Whether or not there's 4 or 5 or 6 documents previously that say this person's not allowed. As long as the person who has authority over the property changes their mind and says, you know what, this has been a big misunderstanding, we'll give you another break and we'll allow you on housing authority property, they can come back. If they dig their heels in and say, I own it, I'm in control of it, and you're never welcome here, then they're never welcome there.
You used the word welcome. And then you said
allowed or authority. Okay.
Then you said if they come with certain documents, then they would be allowed. Does the citation say you're not welcome or not allowed?
You know, I don't know that I know what they say. They make it
Notice of trespass.
Notice of trespass is
okay. Even if we don't know the wording of it, is it
says,
intent to show that you're not welcome or not allowed?
Correct. Yes. Both. And that if you come back, you will be arrested is the last one I saw, but I can't tell you I've seen one within the last couple of years. I just know that they're there.
But it has no legal bearing, you said. It has no legal bearing.
It does have legal bearing based upon the fact that is proof that the person was told that.
I think what he's trying to do is draw a distinction between, like, if you're speeding, if you do 100 miles an hour down Martin Luther King, they're going to give you a ticket.
Of course.
That's the citation. That is a legal charging document. That is the same thing as being handed an information in court. The notice of trespass is a record. It is a slip of paper that creates a record of the trespass warning. That in and of itself will not be a charging document. That is just a record.
Right, I understand.
It just commemorates the fact that this person was advised that they are no longer welcome on this property.
They're no longer allowed.
But yes, allowed, welcome,
welcome
privilege, whatever word.
Plays it down like
sure.
It's not welcome.
Yeah,
sure.
all right,
not allowed. That
no longer welcome is more passive.
I understand what you're saying.
Welcome, not allowed says, okay, if you come back, then you can face possible.
If you come back, you will go to jail.
Right, you go to jail. Right, just saying you're not welcome is not good enough.
Right.
Mr. Isaac, thank you, Mr. Justin, for your information. Ms. Bird asked, who has the final authority, her as a resident or the housing authority as an overseer concerning her welcoming someone to her residence? Am I right in interpreting that you said unofficially or indirectly the housing authority?
No, it really depends on individual leases, to be quite honest. Over the years, Housing Authority has come up with a handful of different versions of their lease, and they say a few different things as far as allowing trespass individuals into your residence and whether or not that's a violation of your lease. They've done different amendments to their house rules as well. I would say that if Housing Authority has a rule that's in your lease that states that you are not allowed to have a trespass individual in your residence, there's some gray area there as to who has that final authority. I can't tell you for sure that that's the Housing Authority. There's still some gray area depending on what case law you look at. We've looked at a handful of different cases over the last couple months when this issue started picking up a little steam. And I can't really tell you, I know that there's good arguments for both ways. There's no definitive case law in the state of Florida that tells you one way or the other. If there's no spoken word about it in the lease, then the tenant herself has that final word.
So basically you're saying that it's subject to individual discretion or individual investigation.
Lease agreements, it's very fact specific.
So it all depends. Because what I'm gathering, and from what I've heard Ms. Bird say and others, I don't know if it was Ms. Bird or the lady behind her that gave, no, it was Ms. Bird. They were playing cards, and an officer came up, and he asked for everyone's ID. And in asking for everyone's ID, does he have the right to do that? Yes, he can ask for ID there, or he can ask for ID on Donald Trump's property. When it was discovered that someone had a felony in their prior, and I think the last young lady stressed that too, they begin to create a uncomfortable situation for the resident that lives there. Now, no one knows who has priors or not. I mean, if I go to play cards with Ms. Bird, they wouldn't know. She doesn't know I have a felony. She doesn't know if I have any type of narcotics or any type of drugs or anything on my pocket. And if some officers come up and they, get my ID and then they run it and they find that out, or they search me down and find that, it puts her in a, precarious situation. She's basically, it sounds like to me, she's trying to find out why that exists. Now, you all are a panel that is here to educate us on understanding simple trespassing. And I wrote down what was given. It says, having authority of a place or structure, and if you're asked to leave and it's met with refusal, then that's trespassing. That means you're not wanted there initially, like when the man was behind your house. It's not that he wasn't allowed, he wasn't wanted. Now, your non-wanting him there created the law to get involved and to bring upon him the disallowment. Correct. You're not allowed here now. And I want to address this to the professor. Given the weight and dynamics of the situation, and from a collegiate point of view, when the numbers were shared with you, you said you were unable to draw any type of conclusion. And then you made a very good point. You said that of the 924 arrests that the city made, and the 454 citations that were given to, and I may have the numbers wrong because I was trying to write and catch up with everyone who was saying, they were not all singular trespassing charges, that a person may have been arrested for something else and then given a trespassing charge. Like they may have been caught for something else, and because they were caught with that, whether it was drugs or any other type of criminal act, they were also giving a trespassing. Given the dynamics of that, is it right, or would you agree to that someone can conclude that this is an arbitrary act being executed by the police, by the City of Fort Myers Police Department?
No, I don't see it as arbitrary. I mean, if they're enforcing the law, it certainly isn't arbitrary. But let me just take a step back with you a little bit. You talked about that situation with the police, where the police arrive at a gathering on the property and they demand everybody's identification. Just because you live under those circumstances does not mean under any circumstances that you forfeit your First and Fourth Amendment rights. You don't. Under any circumstances, that does not take place. That's one answer. But is it arbitrary? No, it's not arbitrary if they're enforcing the law.
But is it an enforcement of the law when you just see people at a social gathering and there's no crime or nothing suspicious going on?
If there's not reasonable suspicion, I don't know why the police would even be talking to them.
Exactly. exactly. And
We're not
and I'm-
talking
and
about probable cause now, we're talking about reasonable suspicion. And there's a vast difference.
in both probable cause. You have to have probable cause to
Well, if
approach.
they're going to speak with them and they're going to conduct an investigation, they have to have some reasonable suspicion in order to conduct that conversation with them. If there's no reasonable suspicion, if you're sitting there playing cards, there's no money present, there's no drugs present, you're not doing anything illegal, what right would the police have to come over and speak to you other than say good evening or good afternoon?
Mr. Justin, can you define probable cause?
Well, probable cause is just what it says. Probable is that the officers believe that there's probably a crime that's being committed or has been committed. I understand what you're saying. I fully understand the picture in my mind of what's happening. Law enforcement officers have the right to walk up to anybody and say, "Hi, how are you?" And you can say fine, or you can choose to ignore them. I mean, I understand the reality when the officer asks for identification. Most people reach in and pull out their identification. But the law says they can ask, but then the person has the right to say, "No, I don't think so, not today."
Do they have that right?
Yes, because what's happening is called a citizen encounter. They just walk up to somebody on the side of the street and say, "Hi, how are you?" And they can have this encounter and ask you for some identification. But you can choose to say, "No, I don't want to give you my identification," and that's as far as it can go.
And the other
Will it go
phrase was
further?
reasonable.
Reasonable suspicion.
Reasonable suspicion. Ms. Fitzgeorge, reasonable suspicion. Can you speak to that?
If they believe that the probability that a crime is occurring or about to be committed, in the case of a misdemeanor, something that occurs in their presence is required.
So they seem to be intertwined. Reasonable suspicion and
they're
probable
not.
cause
They're
seem
close.
to have a type of relationship.
Reasonable suspicion is here and probable cause is way up here.
But she said probably. Reasonable suspicion if they see a probable or probably think that there's a crime going on.
Suspicion.
One of the
Probable
cases,
cause is if you actually see it. What I'm trying to get at is this, based on Ms. Bird's, and I mean, you guys are not law enforcement, of course, but I think what Ms. Bird is trying to say that the use of being able to trespass someone has probably gone beyond the call of duty. That it's being done ruthlessly and without fair and due consideration. And that a lot of law words, legal words, jargon is being used to confuse the people. And Mr. Isaac is doing the best he can. You guys are doing the best you can. You spoke very well about, and thank you for your information, and thank you too, Professor. You all spoke very well. But the people are trying to look for concrete answers, not feathery answers. They don't want light answers anymore. They don't want answers that float. They need answers that are solid.
I think there's a lot of different issues involved here. You know, Mr. Justin and I can talk to the criminal aspect of it, the people that are being arrested for trespass. The bigger issue of what is going on, why is this happening, are people being targeted, what is the meaning of this, and the housing authority issues, those are civil liability issues. So we can't be very helpful with those, I'm sorry.
Thank you, sir.
Thank you. Thank you all.
Thank you, sir.
Thank you for attending.
Back to the panel. We've had some interesting public comments. Have we all, each panel member, have you had the opportunity to express all that you wanted to express about the trespassing law and how it works? I know earlier you said, Kathleen, about how this is also happens in the rural area. Could you elaborate more on that for people maybe in Charlotte County?
Well, certainly. I mean, what we see in the rural areas are less of the invitee or the housing issues, more in terms of whether property is posted sufficiently. Maybe people want to go hunting. Trespass with a firearm can then be a felony charge. So now we're talking about people risking going to prison for up to 5 years. But also the misdemeanor charges. Someone goes on someone else's fenced property. Maybe it wasn't posted, but it was fenced. So certainly, there's all different aspects of trespass. On school property is another issue, whether someone's invited or not, or asked to leave. Or, there's a whole variety of different issues that we face throughout the 20th Circuit and all the various counties. And this is one aspect, certainly. So I hope we've been able to educate some people on.
You guys have anything else to say?
Thank you for the invitation.
Thank you very much.
Do you have anything else to say, Mr. Moderator?
No, sir. I think the panel has done an admirable job. I know, I don't know if everybody watching can see, but Mr. Green had to excuse himself for another commitment. But I do think we all want to thank you for the opportunity to come speak, and hopefully we've clarified the issue.
Thank you. I'd like to, on behalf of Citizens for a Better Fort Myers Government, we'd like to thank our distinguished panel. We hope that as a result of watching this televised discussion on Florida trespassing law, you, the public, have been enriched and educated on better understanding the Florida law. We would also like to thank our supporters who have helped make this possible. Businessman Earl Smith from Bill Smith Appliances and Mrs. Sophia Lewis from Sophia's Bail Bonds here in the city of Fort Myers. We thank our esteemed panel and members from the public for watching us. Thank you.
Thank you all.
Thank you.